Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we have talked about this phenomena on multiple videos now, which was the complete meltdown or tantrum that a lot of blue states had following the Supreme Court's issuing of its holdings in Bruin. One of the states that was absolutely the most guilty of it, in addition to New York and Illinois, of course, was the state of California. Well, it appears that California, even though their May issue regime was soundly struck down that fateful day in the summer of 2022, they just kind of doubled or tripled down and came up with yet a more oppressive regime. That now has finally drawn the attention of some lawyers who are going to try to do something about it. So let's spend a few minutes today, let's geek out, and let's talk about the county that won't issue concealed carry licenses and why they're getting sued. Okay, before we get going too far down the road we're going down, as many of you know, every time we do a video about California, we always give a shout out to our first ever California subscriber. Of course, that is Philip P. Philip P. was subscribing to the channel back when I was rocking this hairdo, and he has been spreading the gospel of Washington gun law down in the Golden State ever since then. Philip P., this video is for you. The case we're talking about today is California Rifle and Pistol Association v. Luna. It is a case that was just filed in the United States District Court for the Central District of California. It involves our good friends over at the Second Amendment Foundation, as well as our good friends over at the Gun Owners of America, and many, many other very, very talented lawyers. What is at issue here is two jurisdictions. One is Los Angeles County, another is a municipality within Los Angeles County, who essentially, since the time of Bruin, have done nothing. And what I mean by nothing is they have literally refused to issue concealed carry licenses to any of the qualified applicants. Now, we're going to get right to it because I think the complaint does a really good job of kind of laying out what's going on here, and I love what the plaintiffs have done here because they're going to take a three-prong attack on it that we're going to get to in a little bit, and then they're going to take on something that I've always found crazy about California. No one's ever really talked about it, and they've come up with a really interesting way to skin the cat. It has to deal with CPL reciprocity or CCW reciprocity. Okay, let's get right to it. The complaint basically states, this action challenges the constitutionality of carry permit issuance policies and laws that make it extremely difficult, if not outright impossible, or impermissibly time-consuming for plaintiffs to obtain permits to carry a concealed firearm in public and therefore to exercise their right to be armed in public as guaranteed by the Second Amendment's text, bear arms, and as recognized by the United States Supreme Court. The main policies that plaintiffs target here are 1. Defendants' failure to timely process carry permit applications. 2. The grossly excessive fees defendants are charging to process permit application and satisfy various permit requirements. 3. The use of highly subjective suitability criteria in evaluating applicants. And 4. The refusal to honor permits issued by other states. These practices and policies, some of which are enabled by state law, violate the Second and 14th Amendment. And it's that last little thing about CPL reciprocity and not honoring concealed carry licenses from other states that we're going to circle back on, because I think it is perhaps the most fascinating thing of what is a really well-crafted complaint. The complaint then further states, in anticipation of bad faith efforts to obstruct its ruling and recalcitrant jurisdictions, the Bruin Court expressly invited challenges such as this one, noting that, quote, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Why would the Supreme Court have ever felt the need to put that in the Bruin opinion? The complaint further states, the policies that plaintiffs challenge have gone far beyond abusing constitutional rights. Defendants have flat out denied plaintiffs their rights to be armed outside of their homes by establishing an onerous permitting regime replete with exorbitant poll tax-like fees, egregious wait times lasting well over a year, and a nefarious discretionary requirements designed to flout the Supreme Court's precedents. And I don't know who drafted that part of the complaint, but bravo, that is a fantastic use of the English language, an incredibly well-drafted part of the complaint. Now, the complaint further then states, for starters, Los Angeles County Sheriff's Department, LASD, admits that it takes a year to a year and a half to process CCW applications. Yeah, and if you think it's bad relying on LA County, imagine if you have to rely on the municipality of Laverne, California, because plaintiffs point out, while the Laverne Police Department's permit application processing wait time is not as severe as LASD's, its application process is cost prohibitive. Applicants pay between $900 to $1,100, depending on the varying costs that third parties charge for the mandatory training course and live scan services. Even after obtaining a permit, LVPD even charges over $500 for renewal applications every 2 years. And to just give you an example of how ridiculous that is, Washington State, a state which I have never been a fan of their gun laws, and I certainly do not get on YouTube to promote how awesome Washington gun laws are. But yeah, our application fee for a CPL license is $36 with a few extra local fees. It will run close to about $50. To renew the application, it is a $10 fee. Again, with some local fees, it will run you about $15 or $16. Washington State requires that you get an in-state permit issued to you within 30 days of the date of your application and an out-of-state permit issued within 90 days of the date of application. Now, the good news, California, is if you live in a town like Laverne, you don't actually have to go to the Laverne Police Department. You could go to the Los Angeles County Sheriffs and they can do it for you, except, oh, that's right, the sheriff won't do it for some municipalities, just simply won't do it. Because as the plaintiffs point out, in stark contrast, applicants in other California counties can avoid high local municipality fees by applying with their county sheriff department instead of the city where they reside, as California law provides. But LASD Sheriff Luna has refused to process CCW permit applications for Los Angeles County residents who live in one of that county's many distinct non-contract municipalities. And then, as if all the exorbitant fees and all the crazy delays weren't enough, believe it or not, these jurisdictions are still subjecting applicants to the criteria that the Bruin court firmly threw out on its ass. Because as the plaintiffs point out, additionally, both LASD and LVPD impose subjective permit issuance criteria in open defiance of Bruin, which rejected such unmoored standards for determining who gets the privilege of exercising an enumerated right. For example, LVPD subjects applicants to an invasive psychological examination. This absurd policy is an outlier even in California. But then the plaintiffs point out something that is really troubling. In California, you need to be aware of this because when Senate Bill 2 goes into effect January 1st, any jurisdiction which orders any kind of a mental health or psychological evaluation, currently state law says that the most you can pay for that evaluation is $150. Senate Bill 2 now says that you are on the hook for the entire thing. And any attorney who's even sent their clients out for mental health evaluations, psychological evaluations, things like that, know that these types of evaluations can run in the thousands and thousands of dollars. Add to that this is government-sanctioned extortion. What do I mean by that? Well, when you get wrapped up in the judicial system, you can be forced to do businesses with certain people. High-risk insurance companies, ignition interlock providers, CAD or SCRAM or electronic home detention providers. These are companies in which government extorts you to do business with, which means for the company, one, they can charge just about whatever fee they want, and number two, they can provide whatever level of customer service they want or don't want to, and there's nothing you can do about it. Now, maybe one of the solutions would be just go get a permit in some other state, one that California honors, and then you'd have concealed carry privileges under that out-of-state license. Many states, even Washington State, permits that from 9 other states. But here's the problem, California. Yet your state apparently is better than everybody else because you do not honor a concealed carry license from any other state in the union. As plaintiffs point out, even if plaintiffs wanted to avoid delay, expense, and suitability requirements from LASD and LVPD by simply obtaining the carry permit from another state, as some of these plaintiffs have done, California does not honor permits issued by any other state. And of course, that also means then that if you have to be an in-state resident to get a California concealed carry license, then no out-of-state resident could ever lawfully carry a firearm inside the state of California. Now, I mentioned earlier that the plaintiffs were taking this really intelligent three-pronged attack. The first attack is pretty obvious. It's the one we always talk about here on the channel, which is they're challenging all of these laws under the Second Amendment. A right delayed is, in fact, a right denied. They're also challenging this under due process or equal protection grounds. As the plaintiffs put here, separately from plaintiff's Second Amendment claim, the United States Supreme Court has consistently held that regulations and classifications that impose a penalty or an impermissible burden on the right to travel violate the Equal Protection Clause of the 14th Amendment unless absolutely necessary to promote a compelling government interest. Absent the state of California being able to establish that compelling government interest, this would be violative of that constitutional principle. And this is a really intelligent and unique challenge here, they're challenging this law, predominantly the issue with the concealed carry license, under the Privilege and Immunities Clause. Now, the Privilege and Immunities Clause, which is found in the United States Constitution, Article 4, Section 2, basically says that states have to honor certain rights that were bestowed upon people in other states. This is where I think the plaintiffs got really creative, because they cite to a case called Obergefell v. Hodges. That is a case which, when I read this quote to you, you will connect the dots. You may not recognize the case. It is a huge case in Supreme Court history. It's just a case that we don't talk really any time about here on this channel because it doesn't pertain to our subject matter. But what was at issue in Obergefell v. Hodges was a married couple had received a marriage license in one state, moved to a new state, and that new state refused to honor that marriage license. As the plaintiffs put it, an analogous issue was already decided by the Supreme Court in 2015. Because Ohio would not allow for same-sex marriages, James Obergefell and John Arthur decided to marry in Maryland. After learning that Ohio would not recognize their marriage, they filed a lawsuit. The Supreme Court ultimately held in pertinent part that the 14th Amendment requires a state to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. And then in further citing to that case, the plaintiffs very wisely pointed out, if states are required by the Constitution to issue marriage licenses to same-sex couples, the justification for refusing to recognize those marriages performed elsewhere are undermined. So it would be like, one state has already gone through a very thorough vetting and background check and said, yes, you have the privilege to carry a firearm outside of your home. Now, I know there's many states where constitutional carry exists, but that is a slight majority of states. Why then, if a state has already bestowed that right upon you, shall the state of California be in a position to say, yeah, but you don't have that right here? Listen, I think this is going to be a really fascinating lawsuit. The pleadings are incredibly well drafted, as I've mentioned before. I don't know how receptive the bench is going to be down there. I've never really found, other than one judge in San Diego, to find a particularly receptive bench down there to much of anything related to these types of issues. But the case, once again, is California Rifle and Pistol Association v. Luna. We're going to link it up down below. I encourage you guys to geek out on the pleadings because I think this is a really, really interesting argument, especially on that concealed carry reciprocity issue. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down in the description box also. Now, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.